Good morning, everyone, and welcome to this new ForoCompetencia event. This is our last breakfast this year, and we had a great year of celebrating our 20th anniversary. And we have the honor to have with us today Professor Eleanor Fox from New York University School of Law. Everyone knows who Eleanor Fox is, and she is one of the leaders that allowed the international development of competition law. So not only at the international level, she played a key role in the development of the ICN, but also she has helped a lot different countries in particular. And today she will be speaking about a topic that is of great importance with regard to antitrust and the growing inequality gap. She has recently prepared a paper, and she has accepted the invitation to share this paper with us. So without any further introduction, Eleanor, thanks again for accepting the invitation, and the floor is yours.
Hello, everybody. Thank you so much, Julian. So it is a pleasure to be here with all of you today. And also, it's a pleasure for me to present this particular paper, which is on inequality and whether competition law can and should do anything about it. I do have slides. I will put them on in a moment. I wanted just to say a word or two by way of background. Well, let me start to share the screen now. Oh dear, what happened to that? Oh, here it is. Okay. Okay. I want to start by telling you a little of the history of this project. And also, as I will go through the remarks I do want to make, you will see I have chosen 4 jurisdictions for the particular study of the history of equality and inequality in their particular competition laws. I hadn't chosen a Latin American country, but I'm thinking, especially now that I am talking to you, there's room for elasticity of this project. I did the paper with my student, Philip Bazanov, and the paper will be published in a collection put together by the University of Amsterdam. Philip and I devised a kind of template for asking certain questions regarding each country about its use of equality and inequality. And it would be very interesting to add another country or two, say from South America, asking the same questions and seeing how they come out on our typology. And although it won't be in this particular paper, given the elasticity of use of the internet, I think we could expand the paper. If anyone is interested, you should tell me, and maybe we could do a piece, a section on your country. So the background of the paper is, I was asked by the University of Amsterdam to do a keynote speech on their project, which is the growing inequality of wealth and income and competition law. The University of Amsterdam has a project on equality, and it has a problem on sustainability as 2 of the big existential questions of our time: the growing inequality gap, and of course, the threats of climate change. And so it seemed to me, as this was presented to me, that my hosts really did want me to make the connections of inequality and antitrust, and vice versa, that whether more antitrust could bring about more equality and help to close or slow down the growing inequality gap. I was somewhat skeptical about that point of view. And I've done a lot of research and reading on the empirical work that has been done on that question. And they wanted a short outline, and I wrote a short outline basically saying the big point where antitrust competition law can help get better, more equality is equality of opportunity, which I think is true. But they came back to me and said, no, we are really doing a project on wealth and income. So they wanted me to think more seriously about that relationship of competition law and wealth and income. So I did a lot of reading on it, and I will mention to you in a few minutes some of the relationships and what I think are very tenuous, sometimes very tenuous relationships, and decided I could contribute very little to that particular vein of the literature. But I decided that what I wanted to do was to look at the historical relationship of the inequality and not even the and inequality value in the competition laws of various jurisdictions, and sort of trace it through history, see whether it really is a value and what it could say to us in the future about can antitrust help close the inequality gap, or at least soften the growing inequality. So I'm going to start with a few words about why I think it was important to do this perspective of history being important, our findings from history. And as I said, I do it in 4 jurisdictions, and then some recommendations and conclusions. So to begin with, the gaps. And I'm sure you know, and you're very conscious of this, that inequality of wealth and income is growing and huge. And in probably most jurisdictions, this is true of the United States. It's true also of many developing countries. And it's certainly true of, I think, most of the South American countries. There is a huge gap in wealth and income of those who are the elites and those at the bottom of the rung. And there are various numbers, and you can dig up various numbers, but for example, like the top 1% own or account for more than 90% of the wealth and income, and a bottom 10% might account for about 1.6%. And in recent times, that gap is growing. I looked at some statistics just this morning on South America. I saw some statistics. The gap is huge in South American countries. I saw some statistics indicating that the gap was particularly growing before year 2000, and then it was much more slowly growing between 2000 and 2017. But I do believe that given the big tech revolution, where and other technological revolution, even in the last 5 years, and especially with COVID, when business where it can has shifted over to internet and played into the hands of big tech, the gap is growing again. So this is the claim of relationship of antitrust and the growing gaps. The claim that there is increasing concentration in markets. This is true of some markets. It's not true of all markets. It's true of a significant handful of prominent markets of necessities. Concentration is increasing. The claim that the concentration causes or results in market power, that with the market power, the increased market power, we have excessive markups.
No, que vos sabés que tuve problemitas con la captiva en el viaje. Si bien no pasó mayores por suerte, pero me tiró falla 2 veces ayer volviendo de corriente. Y te empieza a mermar el rin del motor, te saca el turbo, después te saca el aire. Por suerte pagué, la pagué 1 minuto, arrancó y...
Okay, I muted him.
I'm sorry, if a question was asked to me, I did not understand it.
No, it was not a question. It was someone who was speaking on the phone and didn't put a mute.
Oh, okay. So more concentration, more market power. With more market power, higher markups, and the claim that the gains go mostly to the very rich. They're not distributed to even middle class and poor, and causing more inequality. There are some empirical questions that are problems in making all these links. Some seem to be stronger than others. Some markets are getting more concentrated. Sometimes the concentration actually causes more efficiencies, and consumers can be better off, but it can relate to more market power. If there is more market power, there probably are higher markups. Whether the gains go mostly to the rich is contentious. They certainly don't go mostly to the poor, but there are a number of gains are spread throughout society through now huge stock holding of the middle class. So some of the links are somewhat tenuous, meaning that it might not be a robust claim to say more antitrust and therefore we lessen the inequality gap. And so with my having some skepticism about the strength of the claims, as I told you, I went in a somewhat different direction from the rest of the literature and thought, well, I would look at, is equality a value in the competition laws? And if it is a value, how is it implemented as a value? And what has worked in terms of making equality a value in the competition law, and what can work? And as I mentioned, we selected 4 jurisdictions, and we selected these with thinking about their relevance to the project of determining the importance of equality in competition law and whether competition law can and should advance it. And the bookends here are United States on the one hand and South Africa on the other, and in between Germany and the EU. And I think that we would have several South American countries in between also if we were to do those studies, such as, well, including Brazil, Argentina. Why did we take US and South Africa as bookends? It's for this reason. It's the United States. Let me say a word about the law in each of these countries. United States competition law today has actually rejected the idea that equality is a value. I'll come more to this later, but the United States competition law purports to be pure and simple efficiency, consumer welfare as a value towards efficiency. But the idea is if you incorporate other values, you're watering down the efficiency. So on the one hand, and South Africa on the other hand, where even the very passage of the law was for more equality and dignity in view of the fact that this was post-apartheid South Africa, where the majority of the people had been specifically, expressly excluded from the economic enterprise, and competition law was adopted as a way to get more democracy and integration in the markets. And so the in-between, Germany with ordoliberalism has values that are against power and geared towards more near equality, and the EU value of market integration and openness gears towards less inequality, certainly of the dominant and incumbent firms, and therefore more opportunity and more equality of those who are the outsiders. We asked certain questions of each of these jurisdictions. In some of the jurisdictions, they didn't expressly talk about equality as such. And so we looked for the closest cousins, and the closest cousins are anti-power, pro-democracy, rules that are expressly for the outsiders, not for the insiders, rules that were sensitive to distribution, not just allocation. And these would be rules and principles, for example, on superior bargaining power, excessive pricing, and possibly exemptions when someone at the lower end of the distribution scale would otherwise be hurt. We looked at treatment of small and middle-sized business, workers, and fragmented markets where there were a lot of the little guys. The questions we asked included and as you see, I'm saying an equality value because we are flexible in thinking about what is an equality value. The anti-power and privilege we're taking as an equality value. So is an equality value embedded in the competition law? Is it used, even if it's not? Is it used as a tiebreaker? Is it used for setting priorities? Is it reflected in conditionality in mergers? Is it possibly used, it is in South Africa, as an affirmative action notion to help those who have been the unequal people? And I can tell you in advance, South Africa is the only country I know of that has and does use more equality as an affirmative action principle, sometimes called positive action. So I'll go quickly through, really quickly, tip of the iceberg through the 4 jurisdictions. One thing that was very clear and well known to me as a student of US antitrust law, equality was a value from the beginning of US antitrust laws in 1890. In the sense that it was for the little guy, it was against power, it was against elitism. It was worried about the concentration of wealth and power. Oh, this is just a famous cartoon from one of the early days of the passage of the Sherman Act to show those big guys who are the powerful masters of the trust who have all the money, and the little guys who are depicted as the legislators who are finally getting it together to condemn the trusts. The period in which equality was most clearly asserted as a value was in the 1950s to the 1970s, when equality of opportunity was very much in our competition law, and our competition law was then looked at as a law for diversity, for democracy. The civil rights aspect of law was actually closely linked to the competition law. But things changed. And this is period 2, which is our period now. Beginning with the Reagan administration, the law flipped in terms of its values, and it explicitly took out of the law non-market values, including equality. And the law is libertarian. Antitrust is looked at as allocative, not distributive. It's not hospitable to an equality value. It is often said that if the law looks at distribution of the gains, who gets what, who are the winners and losers, that will dilute the aim to get efficiency. Now, this slide is still about US antitrust, and I wanted to mention a couple of concepts which I'm going to come back to in my last remarks on recommendations. The idea of allocative antitrust means that calculations are done in the aggregate. So if we say consumer welfare, we mean aggregate consumer welfare. If we say total welfare, we mean total, but the total is not adding up individual people, it's adding up dollars or whatever is the currency. And if the rich win more than the poor lose, that satisfies what is the Calder-Hicks principle. And the notion is that is efficient to move society to a point where the aggregate gains increase, and it doesn't matter who wins and loses. And the idea is if you want to help the losers, you do it more directly. And therefore, who wins and loses is from, it could be from a particular action or transaction, like a merger. It could also be from an enforcement principle, like in US, resale price maintenance is under a rule of reason, and it is often fine. It's also often the case that the poorer are the greater losers from resale price maintenance than the richer. So let's leave the US there for a moment. We go to European Union. The big value and point that we're abstracting from European Union is the following: that yes, the EU does have a value that maps onto equality. And that is its basic formulation and value of openness of markets, level playing field, and equality of opportunity. I can't dwell on too much now because of time, but going to Germany, the EU is deeply influenced by Germany, and German competition law today is deeply influenced by ordoliberalism. And ordoliberalism is an order against power. And the idea of greater equality, less inequality is bundled into this idea that no one should have power or should have power too long, that the society, that is the recipe for a competitive and dispersed and diverse markets. And those diverse and dispersed markets will be a check against autocratic governmental power. And South Africa, where the mission is equality at the core, and South Africa is willing to make trade-offs in its laws generally, including the competition law, to help the less well off. So what do we learn from these country studies? So one thing is when equality values are expressed, most often when the word is used, it's equality of opportunity, not wealth and income. However, there is, even saying that, there is in some cases an equality value embedded in the law. And we can see in the United States, there was period 1 where it was, and period 2 where it says, no, it's not. Is an equality value used to prioritize cases? You know, that's quite a different question. And as I see it, and I've looked at a lot of jurisdictions and what they prioritize, the competition agencies usually do prioritize markets that are markets of necessities and where the enforcement will do the most for the most people. And that definitely maps onto or looks in the direction of more equality. And often it's food, healthcare, energy, transportation, and today internet, because that is basic and critical for other than the elite. Is an equality value used in conditionality or clearances or consent decrees? And yes, we do see sometimes that consent decrees will have conditionality in them that's actually unrelated to the market working, but we see this most specifically in South Africa, where definitely conditionality today, even to increase the spread of ownership of the left out South Africans. Is an exemption available? And yes, in Germany and South Africa, and that means supposing that an anti-competitive activity is thought to be let through because it will help poorer people or because the players are the poorer people. And that's relatively rare that happens, but yes, there is the availability of the exemption in Germany and South Africa. And does the competition law, this is of a different sort, a question of a different sort. What do you think on the whole? Does the competition law alleviate inequality? Does it aggravate it? Does it just do nothing with respect to inequality? This is a really important and more overarching set of questions. And I'm asking you to think about it right now. Do you think that your competition law does help to alleviate inequality? Or does the competition law itself aggravate it? Or does it just do nothing about it? And here I want to say a word which I didn't say at the outset, but might have, which is that markets, just the working of the markets, when the firms start to get or can get market power, does have a tendency to work in favor of those who have more in terms of resources, availability, talents, money. They can take advantage of the market wave. And it does tend to work in favor of making people who are better off yet better off. And it can work the other way, that people who are not well situated to take advantage of the market find themselves more unequal. So markets can work in this direction. This is the Piketty line of thought. In my view, it's not antitrust that causes the inequality, but that it's the antitrust that may be sitting back and not taking action against, say, big mergers or monopolistic conduct that could be aggravating inequality. This is kind of a summary slide in a way. If we're going to integrate an inequality and equality value in competition law, how should or would we do it? And we've seen 4 models, which US says just don't, but we see a huge amount of rhetoric and pending legislation. And if you think about all of these bills that are pending in the US Congress, if you read the bills, you will see some of them, like some of the Klobuchar bills, talk explicitly about equality. They talk explicit, this is in recitals at the beginning of the bills. They talk about the growing inequality of wealth and income. and the need for greater equality through antitrust. This could be just rhetoric, but it's in there. And whether or not that is rhetoric, the bills would, if passed, increase the level of antitrust offenses, make it easier to find and litigate against conduct that may be anti-competitive and transactions that may be anti-competitive. So to the extent that the antitrust enforcement, by preserving competitive markets, is keeping more resources in the hands of the little guy and fewer in the hands of the elite, if you think those values do go together, the pending legislation might do something of that sort. For EU, the model, as I mentioned, sympathetic values, openness and access. Germany also sympathetic, and South Africa, affirmative action. There are some ways in which the law will actually prefer historically discriminated against people have an easier chance of proving, for example, a buyer power offense, and in merger conditionality, they are likely to get conditions that will be in their favor for spread of ownership, for example. So having said that, all that I've said before, which was somewhat sympathetic, at least not antagonistic to the idea of equality in antitrust, let's just look quickly at objections, even to that idea that inequality and equality should be considered in antitrust. All right, some of these are overlapping. The idea that competition law is about allocation of resources, not distribution of resources, period. It's not our job. It's like oil and water, not our job. Number two, which takes off from there, that if you're going to go there saying, oh, we've got to put equality in the equation, you will dilute efficiency and protect inefficiency. Number three, that the idea of equality in antitrust is soft, no objective standards, undermines uncertainty, and opens the door to more political shenanigans. Number four, this starts with the idea that antitrust is really about efficiency and consumer welfare, and that the idea that that is the general principle in the world. And if you're going to put equality in the equation, it is a danger to the project of international convergence. Number five, totally different. If you try to put equality in the law, it's not even going to produce equality. You're never going to see, through competition law and equality, you will not see a lessening of the inequality gap, which is caused by other things like historical wealth and technological change. Number six, there are better tools, just use tax. Well, I might like, because I'll end very soon, and I might like to hear your views on this. I think there are good answers to all of these, but of course it depends on how you're going to use an equality value. I think I'm going to leave this probably to our discussion, and we could talk about whether you think these objections are really so great we shouldn't even think about this. My last slide, I think that's the last, yeah, almost. Last slide, my recommendations. I do think that competition law has an essential form of an equality value to make markets work for the people, and to lean on the side of recognizing markets are for the people. They're not for the elite. They're not for making the incumbent more incumbent, entrenched. So I would like to see a recognition that it is a value at the core. Number two recommendation is this. We didn't talk about this, but there's a general feeling very much in the United States, maybe this is a US problem that our antitrust laws are way under enforced. And if we simply, and they're not only under enforced, that our law from our Supreme Court is causing that under enforcement because our law from our Supreme Court is helping incumbents excessively at the expense of helping entry. So a lot of people in the United States, even those who don't want to think about an equality value, are arguing that antitrust should be in US much more aggressive and that our law needs to be reformed, not because of inequality, even because of efficiency and consumer welfare. And so my point here is if you improve antitrust, and given that, if you accept that, antitrust is a pushback on markets that tend to cause greater inequality, you are actually helping the equality value. All right, number 3, I told you I would come back to Calder, Hicks, and aggregates. And I think we ought to be not only doing aggregates, but also disaggregating and asking who are the winners and who are the losers. And it could be, as I said, it could be from a particular merger, but it could also be from a particular or transaction or conduct. It can also be from enforcement against it. And if we find that the poorer people are the consistent losers, our rules are probably wrong and should be revised. But in any event, we should be understanding who are the winners and who are the losers. We should be looking at this. Number 4, maybe in some cases, we should have distributional impact statements, especially where there is a claim that a transaction or an enforcement is having significant distributional effects that are to the elite and against the middle class and poor. Number 5, prioritize. However, I want you to know, I'm saying this as sure, agencies ought to prioritize projects, enforcement projects, where they help mostly the poorer, or maybe the middle class and the poorer, and not the elite. But I think agencies do it. And I think at that conference I mentioned in Amsterdam, with a lot of very aggressive ideas that antitrust should be used to get greater equality, a number of the participants were putting as their number 1 recommendation prioritization. And in my view, they're just not taking account of the fact that agencies do prioritize in that direction, and they're not going to see any changes in lessening the gap by the recommendation prioritize. In other words, that's really a weak recommendation for change. So I think in the end, I think a lot of people, and many at that conference, overestimate what competition law can do to help close the inequality gaps of wealth and income. However, I also think that we shouldn't underestimate competition law as one of the players in keeping markets competitive and therefore more sympathetic to the outsiders who are often the poorer population. Tax law can't do this. Keeping markets open can. What competition law can do for equality, nothing else can do. Thank you.
Thank you, Eleanor, for this very comprehensive overview of the issue, which is definitely an issue in Latin America as well. As you mentioned, inequality is an issue in a major issue in Latin America, and in fact, we're experiencing a situation in one of the Latin American countries, which is very well represented in today's event, and one of the representatives has raised her hand, is Chile, which is now in the process of debating its own constitution based on the social protests that were inspired on inequality issues. So I'll let Nicole speak, and then I'll give the word to Germán Coloma. Nicole?
Thank you very much. Thank you, Julian, for organizing this interesting meeting. Thank you, Eleanor, for your brilliant speech. It was really, really interesting for us to learn from you. Yeah, I'm a practitioner and a scholar in Chile on antitrust law for 25 years. And I had a couple of views about what you said, and I totally agree with what you said, but I think that, yes, it's very interesting to see applications to different countries, right? So I have 3 or 4 ideas about how this could apply in Chile. Let's say, on the one hand, as in the US, we don't see in our law an explicit reference to inequality. So there is an explicit reference to it. And our antitrust court, we have a specialized antitrust court, tends to judge in similar terms as the US Supreme Court would. But when it comes to our Supreme Court over the last 7 to 8 years, the Supreme Court has included in these broad concepts as antitrust, relevant market, market power, abuse of dominant power, cartels, the Supreme Court has included equality concepts, explicitly. So it's not that the law includes the concepts, but it's the interpretation made by the Supreme Court which is including those concepts. Let's say protection of smaller companies, even if it's not like a standard antitrust law application, or a protection of even, they are questioning in some cases volume discounts because they feel that big companies get to this discount, but not small companies. We have like 10 to 15 decisions by the Supreme Court that could be considered like pro-equality. They are pretty, criticized by scholars and by practitioners in Chile because the view is, this Supreme Court is generalist. They are not really applying, correct antitrust law, but it's a very interesting trend, I would say, and we're really, closely following what is happening in Chile about that Supreme Court. This is one view I wanted to share with you. The other one is that, yes,
could I stop you just to make a comment?
Sure.
Because that's so interesting. I would be really happy if you could write me an email that gives me a link to the literature, even if it is just in Spanish, because I will take care.
I
won't be able to understand, but I will take care of it. And then I wanted your opinion on it. Do you think that it is too unhinged from the proper goals of antitrust and therefore maybe should be criticized, or do you think they're on a right track?
I have like mixed feelings about it. From one perspective, my antitrust heart doesn't like it because they are too unorthodox in some cases, and they even, decide in a wrong way, applying wrongly some economic concepts. But I understand the spirits that is behind this. I understand that the view, is a well-inspired view about, protecting the poorer or protecting the ones that are less, favorized. And I feel that we should work in giving the antitrust court more, technical tools for them to decide well inspired, but using, correct antitrust tool. Because as you say, I think that this could be attained by applying good antitrust law and not by like creating other reasoning that it's not, right from an antitrust perspective. But we have a lot to work with the antitrust court with the Supreme Court on this, and even more advocacy between the antitrust court, which is very specialized, with the Supreme Court on this.
So thank you for that. And go to your second point. I'm sorry, I interrupted.
No, I don't want to monopolize the conversation. So very, very shortly, I think that, yes, we have, in the law, we prioritize markets in the sense that, for instance, we have criminal sanctions for cartels now, and our antitrust prosecutor must, follow an antitrust sanction, a criminal sanction when it comes to very essential markets like food or medication. So our law prioritize from that perspective. I feel that is consistent with what you mentioned. And the third idea I wanted to share is that I feel that if we review our precedents, I think that they definitely, they definitely are not neutral regarding inequality. They helped to a more equal system. The examples are our cartel cases, the more emblematic cartel cases in Chile that were prosecuted and where the antitrust court imposed, high fines, and the Supreme Court confirmed these fines are on medications, food like poultry, chicken, toilet paper, transportation. So all these very emblematic cases are normally on prices, or market allocation, and definitely, if we analyze the prices before and after, we could probably find that prices got lower after the antitrust decision. So I think that from that perspective, they are definitely not neutral, and they helped to a more, to more equality in our country. So happy to share with you these views, and I'm going to send you an email. Thank you very much again for your interesting speech.
Herman?
Okay, thank you very much, Professor Fox, for your presentation. That was very interesting. I have a question, which is the following, because this idea of antitrust and equality and inequality, in my mind, I have always seen it as something strictly complementary. For example, here in Argentina, it's relatively common when you have an antitrust decision that, for example, goes against, sets a fine or prohibits or conditions a merger, that after you made a consideration related to competition or efficiency or whatever, you also add some considerations about inequality. And you say, well, and this cartel is also bad because it hurts the poor or so on. So it's relatively common that if both objectives go in the same direction, that is efficiency and equality, then you mention them in the sentences or in the resolutions of the cases. But my question is the following, and I have never seen, and that's why I ask you if you have seen any case in any country in which that happens, that if you have a case that goes against efficiency, for example, a cartel, you have a cartel and you have proved that there is a cartel, and following the traditional antitrust considerations, you would say, this is an antitrust offense, you should punish it. Based on equality considerations, you say, no, but because of equality considerations, it's okay. So that would be a proof of saying equality is a different objective to efficiency. Because I think it's very common to have cases in which equality could be a plus. So we say, this is inefficient and it also hurts equality. But the other way around, have you seen any case, for example, in South Africa or in one country like that, in which you say, well, no, this cartel is okay because it helps equality? That's my question.
So great question. And yes, in South Africa. So I want to say two things about that. One is in South Africa, they would be much more inclined to say, for example, this is a collaboration of the small firms, and they need to do it because they're historically disadvantaged people, and we need to let them do it because they should get an exemption or exception. So this is what I think about cases like that. Number one, the agency isn't doing sufficient antitrust analysis because in most of these cases, unless you're getting the whole industry together, but in most of these cases where you have small and middle-sized firms that are collaborating, they're doing it for an efficiency reason, to share risks, and there's other competition on the market, and they are not, it is not anti-competitive, and they do not need an exemption. So one of the points that I've been trying to push with a lot of developing countries is first, before you think of exemption, do your homework and analysis on whether this if it's collaboration hurts or harms competition, because you probably don't need an exemption, and you can get very sloppy if you just say, oh, there's small firms, they're historically disadvantaged, we want them to have more freedom. So that's one point. So what if actually it does harm? There is some kind of collaboration by historically left out people, and maybe this question was pushed under COVID sometimes, where sometimes collaborations were allowed that might not otherwise, that might be on a borderline, might not be otherwise allowed, but where the collaboration might get scarce goods to market more efficiently when the speed was necessary. So this would be a borderline. It might otherwise, it might be big firms. So I'm not going to that point of inequality. Might be big firms that want to collaborate and say, we will do this efficiently, we'll get the masks and the vaccines, et cetera, we'll get it to market faster. So my advice usually on that is, because if it is big firms, if it is anti-competitive, if it is going to hurt consumers, really be cautious that what these firms are arguing is true, that they really need to override antitrust for a greater important crisis value. And it's often not true that they could do it alone just as well, and they're trying to just escape it. But that was kind of a tangent, because that wasn't really it wasn't about equality, but it was about when do you bend the law for a higher value or for another value. So the other thing I wanted to say is, in South Africa, their law, for example, on mergers, allows the prohibition of mergers on public interest grounds, even if the merger doesn't lessen competition. And there are mergers that are perfectly fine competitively, where today the agency is very concerned through certain new amendments about the distribution of wealth and ownership, and is actually requiring the companies that are the merging companies to do something, some conditionality, take on some project that will help spread the ownership to historically disadvantaged people in South Africa. And that is an example where a transaction that might be perfectly good and efficient and helpful to the people might not be able to go through without recognizing and satisfying some concerns for equality. So thank you. I mean, I think that's a really good observation, and I think it's true. And I think in a way it can be how you say the rhetoric, because in most of these cases where it's a cartel and it's hurting poor people, should the agency be able to claim, oh, look at all the good we're doing for equality? They do claim it, but it's sort of a byproduct. They're not doing it for that reason. They're not doing it for equality. They're doing it for markets.
Esteban.
Thank you, Juliana, and thank you very much, Eleanor, for having you here in ForoCompetencia. Just to mention a couple of issues, your presentation was very good, interesting, and complete. So maybe I want to stress a couple of issues that I think are important in Latin America. First of all, I really appreciate your observation about the prioritization way of having equality issues into account. So I think this is a very important way to use this equality considerations, and I think as Nicole mentioned, in Chile it is applied in many countries, and it's a very good observation and recommendation. Also, the equality of opportunity to avoid the exclusion of efficient competitors. But maybe what warns to me, I think this could be dangerous in Latin America to give or maybe to to widen the objectives of the law and the way, because these needs for the people in making the enforcement, the commission, the administrative tribunal or the judges, to apply a certain degree of discretion. And I think this, you mentioned in the pros and cons analysis, but I think in Latin America we can stress that it can be used to political use the antitrust tools with another goals, not from the protection of good behavior of markets and the better functioning of the economy. So maybe the competition law has effects on inequality and another important aspects, but maybe there is a difference between effects and goals. So I think prioritizing is a very good way to enforce in markets where the effects are to lower the inequality as well as improving competition. But I think it's very important to take into account the political economy of this discussion in Latin America. And I am afraid of, and my question is, if you do not think that it's important how this will be applied, and maybe you have some recommendations, because how to have some instruments, how to apply this concept, because in the hands of maybe a populist enforcer, it could be dangerous for the economy and the society.
Oh, so I think that's a really important comment. And, you know, I might be able to clarify the paper a little to say that, because it can be dangerous. And if it's dangerous, it's opening the door to discredit. It can open the door to corruption. It could also open the door to actually watering down the law. I mean, even good faith people without corruption want to protect the small guy and can destroy an economy, depending how far they go. So one really interesting question is, when an enforcement is protecting inefficient firms, that's the SME problem. If you give too much leeway to inefficient firms' protection from competition, that is a problem, and that should be avoided. So I think that recognizing trade-offs is vital. I think that the best way of incorporation is a settle from the roots way. I mean, it's roots up. It's sort of recognizing, and this is just a simple idea, that antitrust is really for the outsider. It's not for the insider. It's not for helping the incumbent, unless that really does help society, but it's much more for helping the entry and tearing down artificial barriers. And that's a foundational position, that you analyze what is anti-competitive from that foundation up. It can inform the whole law. It's part of the rule of law principles. I have been critical of the US law today, so have a lot of people, for protecting incumbents in the name of protecting freedom of that firm, and not doing enough to protect entry. So if you talk about the problem that way, and it is essential to the foundation, and you're really looking at tearing down barriers, I think it's helpful. But if you're opening the door to say, oh, and this is one of our goals, and we're going to look at what's good for equality in every case, that's going to be very harmful. So I think I can do a little more clarification in my paper, because I didn't say in my paper how dangerous it can be. I think because maybe I was leaning on the side of this audience that I was writing it for, and trying my best to think where it really fits without backsliding to harm markets. So thank you.
Thank you, Eleanor.
We have Jose Pepe.
Okay, thank you very much. I really like your presentation. I was looking at the report of a conference, a recent conference at the Peterson Institute on a taxonomy of the different policies that affect inequality. And I found it very interesting to see how they answer the question, at what stage of the economy does policy intervene? And they classify antitrust laws at the production stage. Some policies, such as antitrust, intervene directly at the production stage, meaning they affect the composition and organization of production, and they determine relative prices and incentives. And I really like your statement in the sense that what competition law can do for equality, nothing else can do. And that means to me, shaping, affecting the primary distribution of income. You can also have other policies, which they call pre-production, which shape the endowments with which people participate in the market process. And also you have redistribution policies, such as transfers for the poor, etc. To me, that key point is crucial, because the fight against inequality cannot rest entirely on pre-distribution policies or in redistribution policies. The very process of price formation is essential to me. And the second point I wanted to make has to do with the fact that the more you have power concentrated in a few hands, the rules of the game are biased towards the interests, of course, of people who have the power to make the rules. And those people are mostly, in our countries, that's the political economy, at least in the case of Peru, very wealthy people, conglomerates, and so on. Then you have all this literature on revolving doors and so on, conflicts of interest. So that side of the political economy of antitrust could help you elaborate a little bit more on the Latin American experience, such as in the case of Peru. That was the point I wanted to make.
Yeah, thank you. I think that's very helpful. And I didn't go into that aspect of it, but it's definitely true that if you are if the law is such that it is favorable to the elite, there is a political dimension, political policy dimension, as well as an economic dimension of who makes the rules. And I also, I mean, it's not what you said, but along that line, let me rephrase that, because I want to make a point, and it might not be related to what you said at all, but this is on the side of a concern about inequality. A concern about inequality and growing inequality is who makes the rules, definitely, but also the severe inequality tends towards political unrest. And if there is severe inequality, you're more likely to have revolts and protests. And that's simply a background thought as to why one might be very concerned about severe inequality. It doesn't tell you what to do about it and how much antitrust can do about it, but it's definitely the background of, I would say, the world thought rhetoric to say we've got to attack severe inequality and severe growing inequality.
Thank you.
There is one question in the, well, we have Juan Cristobal.
Hello, well, thank you, Julian. Congratulations, Eleanor. I was kind of hesitating because many of the things have been already said, but I would like to remark one thing you said, Eleanor, about how competition law may help on the inequality dispute. When you say that competition law may be very helpful in order to lower inequality by lowering entry barriers, by lowering exit barriers, by making the process more competitive so it may be more inclusive, I think it can give a big improvement in that sense. My fears, though, is that when you raise the flag of equality as a way of protecting the weak against the more powerful in the market, you may eventually end up doing just the opposite. Someone pays that bill. So when you are trying to protect the small shop around the corner against the supermarket that is coming, and people, consumers, are willing to buy at the supermarket because the goods are cheaper and there are more alternatives, eventually someone is paying the bill, and that person who is paying the bill, it may be even poorer than the one that is being protected. I'm not willing to make any diplomatic row here with Argentina. We've had one already with Ambassador Bielsa. But if, for instance, if you have a certain amount of money and you want to buy a car in Chile or you want to buy a car in Argentina, it is far more expensive to buy a car in Argentina. So for the same amount of money, you will get a worse car. And that is basically because you have more protection for the national industry. Here in Chile, the national industry disappeared because we opened the boundaries long ago. Several companies went to bankruptcy. Today, we don't have any production of cars in Chile at all. But we Chileans pay less money for a better car. So eventually someone pays that bill. And in the name of equality, you may end up actually harming people who may be even poorer than the one that you're trying to protect. So in that sense, I think if you keep competition law more focused on what they do well, like lowering entry barriers and exit barriers, and trying to get away from this type of protection, which may end up in cronyism and lobby and a lot of political discretion, we may end up better off. Thank you.
So I think that's very well said. And we don't want competition law to end up hurting the people that we're trying to help. I'm wondering sometimes, there's this problem of legitimacy. I'm wondering sometimes if antitrust doesn't give enough information and sell itself well enough to prove or show to people that protecting competition is the better route, and that sometimes there are losers from competition and they shouldn't be protected by competition law, or else it destroys competition law and it destroys markets, because there's definitely this area where equality can come in and it can destroy what people trying to help equality are trying to do. So coming back to this point on legitimacy, I think that the world faces a legitimacy, the competition law faces a legitimacy problem. There are people not too knowledgeable about the economics of competition and saying, there's so much exploitation in the market. There is such huge firms, they're enveloping us, they're controlling us, and they're exploiting us, and antitrust should solve our problems and help the poorer and the small business. And they don't have a good understanding of the economics, just as you have said. Antitrust cannot protect and help the weak for the sake of doing that and still maintain its goal. So do you think that there needs to be more rhetoric that actually antitrust could feel more legitimate to people if they understand better? Or is that a lost cause? That there's a margin in which they're not going to understand better. And if they're equality-minded people that don't understand economics, they're just going to keep demanding that antitrust protect small business against low price of supermarkets. I don't know.
I think it's a challenge we're having, and at least in Chile, competition law is being perceived as an elitist kind of field of law, and we're having some problem with that.
So on the legitimacy problem, I have been taking a position that is totally consistent with what you have said about not protecting the weak, but that there is still a role that we can and should recognize. And I mean, you've articulated it too, that this role of tearing down barriers, there is a role and we could do better, that US could do a whole lot better in making antitrust seem a lot more legitimate to people who think they're left out, even though it can't go in the territory of simply protecting weak against efficient. So I see Eduardo, and hello, Eduardo. It's nice to see you.
It is my pleasure, Eleanor. It's great to see you after many years.
Yes.
Eleanor, let me just briefly continue on this part of the discussion. Recently, we had a panel of former ICN chairs when the ICN had its 20th birthday, and one of the discussions that we had was precisely the lack of advocacy at the international level, the lack of advocacy of competition authorities and the international network itself to try to convince not only the people, the everyday people, but also the politicians of the importance of competition and to defend competition. I mean, what we are seeing in many countries, not only Latin America, but in Latin America, it's also the case of Europe and some Asian countries as well, is the lack of trust on markets, on market-oriented policies, and market-oriented, well-designed policies that promote a competition for the well-being of the majority of the population. And this is something, I think, part of the problem is that we have not been able to convince people on the importance of defending competition, to defend the interest of the poorest people, and this is creating a lot of a lack of legitimacy, and I think I go in a line, a similar line of what you have been discussing now, and I think this is a matter of a concern. I don't know what would be your reflection on this issue, Eleanor.
Yes, I think that's very profound. I think yes. The people, if there is such a thing, but I think the people think there's no reason to trust markets. They've seen markets leading to great exploitation and huge power that they think is overwhelming them. And also they're trying to push back and say, use antitrust in a very unformed way against these big players. I think that we have to do more. This is why I'm saying to disaggregate winners and losers, that it's not enough to simply say on the aggregate people are better off, that we should disaggregate winners and losers and know who are the losers. And sometimes society has to come forward and help the losers. And sometimes it doesn't or it won't. So for all of the small business put out of business by the efficiency of an Amazon, if they can't stay in business, society is not going to just come forward. I mean, their government's not going to just come forward and say, oh, we subsidize you. We're so sorry you went out of business. I mean, that is about the working of the marketplace, and the better firms probably will survive. On the other hand, I think we could do a much better job, at least given US law in the United States. Our law is not sufficiently condemning abusive practices that are really abusive and hurting the market because of a conservative nature of our law, not recognizing anti-competitive practices. I think with a higher profile of doing what is necessary to prevent real abuses that are hurting the market, that it would be somewhat helpful. But this is just like, I could translate what you said to our elections. I mean, even think US, think back 2020 elections when Hillary Clinton was not serious enough about who were the losers in society and what we needed to do to address their claims. And this is what she called the deplorables, which came back to haunt her a lot, but it turns out what she called the deplorables were the people who were just feeling society wasn't working for them. So I think different societies have to work much harder to hear the claims of the left out, of the losers in situations where there are winners and losers, and think about how to address those claims. This is not antitrust. It's almost all not antitrust at all.
Perfect. There was a question in the chat from Benjamin Greve in Chile saying that the competition law in Chile already has the objective of in this law to promote and protect competition. Whether you agree or not in the idea of including equality as a goal.
So I think that the goal of competition law is markets, making markets work better. I think it can mess things up when you say equality is a goal, but this is about rhetoric. I think that helping the outsider is part, I mean, markets ought to work for the people. If they're really working predominantly for the elite, that's not doing their job. And in that sense, there's an equality principle, or more nearly, it's not equality in the sense that everybody should be absolutely equal, but a recognition that of inequality and severe inequality without mobility is a very bad thing for society, and that antitrust through more nearly open markets can do something about it. So again, I'm going to a foundation for how you're going to decide what's anti-competitive and whether you're going to lean more on the side of opening markets or on the side of freedom of even the dominant firm, but not a goal in itself. However, you know, Africa, South Africa does have equality as a goal in itself, and I'm watching it closely. It's dealing with all of these problems that you and I are highlighting as very serious problems, and sometimes going overboard in a way, but having guidelines and trying to deal with this in a rule of law way. So it's definitely a country to watch. Because it's dealing with this head on and it's not hiding the ball.
Great. Well, Eleanor, your final words.
I'm sorry, did you ask me?
Yes, your final words, please.
Oh, my final words. Oh, okay. So my final word is, you have all been really helpful. I think this is a really interesting conversation and should go further. I have, as I told you, I wrote this paper for Amsterdam. I've given a talk on this more or less to academics, for example, and others. But I think this was one of my most interesting conversations, and I want to carry forward some of the things and draw upon some of the things that you all have said. Thank you.
Great, thank you very much. It has been a great pleasure for all of us. Well, this is the last breakfast of, as I said, of this year. So I wish you a great end of the year and the beginning of the year, and we'll see each other next year again with a new set of events. Thank you very much.
Thank you so much. Great discussion.
Thank you.
Congratulations.
Thank you, everyone.